The Buccaneer project is funded by the European Regional Development Fund through the Ireland-Wales Cooperation Programme.
Welcome to the Buccaneer video series. This is one of 2 short videos which will help you to discover, define, develop and deliver your skills around intellectual property. This is video 2, Develop and Deliver. If you're new to the series, intellectual property is just a small part of the wider Buccaneer journey, which includes all stages of the innovation process for small growing firms. Whether you're interested in coming up with new products, validating them in new markets, or building your networks to exploit your intellectual property, there's a video for you. When considering the legal implications of intellectual property, it is important to work with experts. Commercial lawyers and legal advisors can specialize in this area and help you to protect the intellectual property that you've created, as well as advise you on the value of the property you're thinking of buying or licensing. Rhys ap Gwent is a commercial solicitor at Greenaway Scott, based in South Wales. Rhys is an expert in intellectual property. Here, Rhys provides some guidance on the common issues that businesses face when thinking about protecting their intellectual property.
People often ask me questions about patents, and people want to patent their business, but it's often not the appropriate avenue for most new businesses, because a patent only applies to a completely novel process or a novel application of an existing process. But if you've created something like an app or a piece of software which uses just established practice, it is unlikely to be patentable. There might be copyright in the actual coding of the software, but if you're just using established sort of software processes and software ideas just to deliver some sort of retail service or any product, provided that that product isn't completely new, it's unlikely that a patent would be the appropriate avenue to pursue. Some of the pitfalls and things to think about, things to avoid and things to make sure of for new businesses really stem from the fact that the IP in a startup it's either the only value or significantly most of the value in the company. So it's important that it's all protected. And in the early stages of starting a business, people are likely to be discussing things or collaborating with other third parties. So it's important in all these agreements, be it confidentiality agreement just at the outset to discuss various ideas, or if it's a more formal collaboration agreement or even a supply agreement. Even if you're starting to talk to distributors, at an early stage you're going to be revealing a lot about your IP to the various third parties that help you from the very beginning. So the first thing to do is to make a list of all the different types of IP that you've got, and then always be mindful of that to make sure that you've always got that at the front of your mind whenever you're entering into any relationship with any third party. As a solicitor advising people on how to protect their IP, I think the most important thing is that people speak to an advisor before they really share their IP with anyone, or certainly before they've signed anything.
Open innovation promotes the use of external as well as internal idea sourcing and routes to market through licensing, patents, spin-outs and collaborations with diverse stakeholders. Open innovation can be thought of as a funnel. With a traditional innovation process, ideas start at the top of the funnel and work their way down until a few reach the bottom and come out as fully formed commercial products. Open innovation encourages the movement of ideas and technology in and out of the firm. They may buy in IP, they may buy in new ideas and technology, but they also can develop them and sell them out into other markets. If ideas are developed internally but are not suitable for your strategy, this can be a very profitable option. You could create a new technology spin-out, which is an alternative form of commercialization that reduces the risk by setting up a brand new company just to take advantage of the technology that's been provided. Or you could look at commercializing new technologies that are purely about your area of market focus, buying them in just at the point of commercialization. Finally, you can have product out co-branding, where you bundle your product with another company's, combining your intellectual property. Here is a top 10 list of how to go about creating an open innovation process for your organisation. 1. Create a needs list. 2. Define the company's core competencies. 3. Initiate scouting. 4. Redefine your IP strategy to accommodate open innovation. 5. Broaden outreach to additional stakeholders. 6. Let everyone know you're open to innovation. 7. Transform existing relationships, for example, elevate suppliers to become strategic partners. 8. Build a knowledge base. 9. Collaborate with peer organizations. 10. Celebrate and showcase successful collaborative innovation projects. Now that you've thought about your intellectual property and maybe the new knowledge that you can bring to market, you'll want to think about 2 new areas. How do you commercialize that knowledge? And how do you fund it? Come back for the Buccaneer video series on new venture capital and commercialization to learn more. Thank you for watching this short video, part of the Buccaneer Innovation video series. Please visit www.buccaneer.eu to find out more.